The role of Hadith in Ikhtilāf among Muslim jurists. Kinds of Naskh. It is generally agreed that the sources of the Sharia that could be subjects of Naskh are the Quran and the Sunnah, both types, Mutawatir and Ahad, and not Ijma' and Qiyas. In view of the above statement, Naskh could be of 9 kinds. 1. Abrogation of the Quran by the Quran. 2. Abrogation of Mutawatir Sunnah by another Mutawatir Sunnah. 3. Abrogation of the Sunnah Ahad by the Sunnah Mutawatir. 4. Abrogation of the Sunnah Ahad by the Sunnah Ahad. All the Usul scholars recognize the above 4 kinds of Naskh. 5. Abrogation of the Quran by the Sunnah Mutawatir. 6. Abrogation of the Sunnah Mutawatir by the Quran. 7. Abrogation of the Sunnah Ahad by the Quran. The majority of the jurists recognize the above 3 kinds of Naskh are against Imam Shafi'i, who does not uphold their opinion. And number 8. Abrogation of the Quran by the Sunnah Ahad. 9. Abrogation of the Sunnah Mutawatir by the Sunnah Ahad. We shall not discuss in detail all of the above categories of Naskh, but shall confine ourselves to the Naskh of the Sunnah by the Sunnah, which is the theme of our discussion. The jurists agree to these kinds of Naskh of the Sunnah. They are 3 types: Naskh of Mutawatir by Mutawatir, Naskh of Ahad by Ahad, Naskh of Ahad by Mutawatir. As for the Naskh of Mutawatir by Ahad, there is some disagreement in this regard. Shawkani, Ibn Hazm, Ibn Subki permit this kind of Naskh, whereas the majority of the jurists do not. However, the Hanafis allow Naskh of Mutawatir by Mashhur. The majority of the jurists argue that Mutawatir is Qat'i, established with definitive evidence, and Ahad is Dhanni, established with speculative evidence. Therefore, the latter is weaker than the former, hence incapable to abrogate the former. The majority also argued on the basis of facts and claimed that they never came across any example where an Ahad might be abrogated a Mutawatir, may it be the Quran or the Sunnah. As for those who allow Naskh of Mutawatir by Ahad, they argue that Ahad is a source of the Sharia, and when a source, as is the case with other sources, is in conflict with another source, the latter in time abrogates the former. So the same principle will apply to Ahad too. They also claim that this kind of Naskh was actually taken place. If we recognize this principle, it would mean that the Naskh of Mutawatir by Ahad is possible. They also contend that as according to Hanafis, Naskh of Mutawatir by Mashhur is possible. So why that Naskh of Mutawatir by Ahad? It is interesting to note that all the jurists who have discussed the Naskh of Mutawatir by Ahad quote an example of the Naskh of the Quran by the Ahad. No one has ever come out with an instance where a Mutawatir Hadith has been abrogated by an Ahad Hadith. Ghazali and Qurtubi have adopted a different view. They uphold that abrogation, i.e. Naskh of Mutawatir by Ahad, was possible at the time of the Prophet and not after him. However, I disagree with them because the Ahadith were not categorized at the time of the Prophet into Mutawatir and Ahad. This differentiation took place when the ulama found the science of Hadith and divided Hadith into different kinds. Conditions of Naskh. Naskh takes place only when certain conditions are met. Otherwise, the practice on various Sharia rules shall have to be discontinued. It is important for Naskh that there should be 2 conflicted nusus that could not be reconciled in any way, because if reconciliation is possible, the Naskh will not take effect. However, the question arises, is it possible to accept a conflict between 2 nusus of the Sharia, whereas their underlying basis and the source is the same? Mustafa Zaid argues that this contradiction is not factual. This figurative contradiction, as he calls it, is normally the basis of Naskh, whereas if we go deep into the matter, we realize that the aforesaid contradiction is not based on any solid ground. The periods of practice on Naskh and Mansukh are always different, whereas one of the conditions of affecting Naskh is the unity of time between the conflicting nusus. Therefore, so long as the period of practice on the nusus remains different, there does not arise a question of contradictions between them. It seems appropriate at this point that we discuss the essential conditions of Naskh. May these be related to Nasikh or Mansukh. The conditions attached to Nasikh are as follows. 1. It is essential that Nasikh be an order of the Sharia. No other cause is valid to abrogate a Sharia order. 2. Nasikh should come later in time than Mansukh. An exception or condition attached to a Sharia rule will not amount to Naskh. 3. Should be at least equal in degree. Naskh should be at least equal in degree with Mansur in the matter of authority and proof. As for the conditions of Mansur, they are 1. Mansur should be a practical Sharia rule. Naskh cannot take place on rules related to belief and the hereafter. 2. Mansur should be temporary in nature, because if it is, the practice on it would automatically end at a given time, and there would not be a need to introduce Naskh in such a situation. 3. Any Sharia rule that is valid for all times to come cannot be subject to Naskh, for the lawgiver, Allah, does not declare a rule to be effective forever and then abrogates it. Rules of permanent nature are those general principles on which the welfare of the people depends, such human acts are judged by the intention of the doer. 4. Mansukh should precede Nasikh in time. Naskh does not take place until Mansukh has been in practice for some time before it and is replaced by Nasikh. 3. How to distinguish a Nasikh and Mansukh. When two ahadith contradict each other and cannot be reconciled in any possible manner, it becomes necessary that one of them may abrogate the other, and obviously the latter in time is the Nasikh. But the question arises, what are the ways to establish that which one of the two hadith later in time so that it is regarded as Nasikh? The jurist here suggested various ways for this purpose. 1. There might be a clear statement of the Prophet indicating the respective period of timing of two legal rules, such as, I had forbidden for you to visit the graves, now you can visit them. It is quite clear from this statement of the Prophet that the permission to visit graves is granted subsequent to the prohibition in this matter. Such clear statement could not be that of a companion, such as Jabir, who says that the last order of the Prophet in this regard to ablution was that it may not be performed anew after eating anything that has been cooked on fire. This just is the reversal of the first order in this regard. Ibn al-Jawzi says that such statements are clear indication of Naskh. 2. The date of both the conflicting ahadith can be determined by the statement of the narrator. Example, Aisha states that the Prophet used to have sexual intercourse and did not take baths, but this was before Mecca was conquered. After that he used to take baths. The narration of Aisha determines the date of both legal orders. 3. We have already mentioned that ijma' does not abrogate, nor can be abrogated, but it can help determine another nasikh or mansukh. For example, there is an ijma' that the order to fast on the day of Ashura is mansukh, and the order to fast Ramadan is nasikh. Barzanchi maintains that an ijma' on the continuation of practice on any nas of the Quran and the Sunnah is regarded by the Usul scholars as valid ground for nas, even if the nasikh is unknown, for it's presumed that ijma' could have been based on the Quran or the Sunnah. The above statement is not correct. How is it possible that the nas may take place without knowledge of the nasikh, and if the ijma' is based on the Sharia source, it should be known to everyone? Shafi'i also rejects the above proposal totally. This, according to him, would culminate in the loss of a great number of ahadith. People might claim that this hadith is mansukh without bringing out the nasikh. So Shafi'i explains in detail the necessity of the fact that nasikh be very well known. He repudiates the stand of those who say that ijma' is enough to claim a nasikh without indicating the nasikh. Repudiate. 4. Juristic controversy arising out of naskh. There has been a great deal of controversy among the jurists around the various juristic rules due to the attribution or otherwise of naskh to those particular ahadith on which they have based their conclusions. A great deal has been written on the subject of naskh, but most of these works are related to the nasikh and the mansukh verses of the Quran. Very little has been written on the abrogation of the Sunnah. The most renowned work is a work by Al-Azami. He mentions certain ahadith which have been subject to controversy among the jurists with regard to the naskh or otherwise. I believe that the said author has not encompassed all the hadith that have been claimed to be abrogated. Some works on this topic are still in the form of manuscripts. Mention may be made of them: Naskh al-Hadith wa Mansukhihi by Abu Bakr ibn al-Athram, Naskh al-Hadith wa Mansukhihi by Ibn Shaheen. Hazmi's work is entitled Kitab al-I'tibar fi al-Nasikh wa al-Mansur min al-Athar. The jurists are in disagreement on certain issues because they reach varying conclusions with regard to the abrogation or otherwise of hadith on which they have based their argument. We may enumerate some of their relevant juristic rules.